afternoon and a warm welcome to Voice's education series for this afternoon, Legal Documents to Have in Place. My name is Jamie McGeechan and a warm welcome to you all. On today's session, we will be looking at legal documents to have in place, the importance of individuals of all ages to consider their plans for end of life. Legal experts recommend having documents in place to help loved ones navigate your health and finances should the need arise. Whether you're planning your own future or trying to help a loved one make these important decisions, our speakers can help you understand and prioritise the documents that you need in place. Today, we'll learn about the next steps if your loved one did not have adequate documentation. And I would like to introduce one of our guest speakers for this afternoon. It's Brian Quinn from Quinn Estate and Elder Law. How are you, Brian?
Good afternoon to you, Jamie. Thanks for having me.
Thank you so much. We're very much looking forward to the presentation. Very much looking forward to it. Thank you for your time and your participation today.
I appreciate it. Thank you.
Thank you. Before Brian's presentation, we have a presentation from Paul Gantner. Paul Gantner is an owner of the estate planning and elder law firm Gantner and Capriano. Along with his law degree, Paul holds an MBA, is Veteran Affairs accredited, holds an active insurance license. He is rated 10 out of 10 on AVVO, which considers experience in both peer and client reviews. Paul's mission is to help families secure their legacies by embracing clients as members of his law firm, family through long-term personal advisory relationships. And now, without much more ado, we're going to watch a presentation from Paul.
Hi, I want to start by welcoming everyone to the community education event, graciously hosted by Voice. And I want to thank Jamie for inviting me and Brian for this awesome event. We're going to talk about some legal documents that you need to have in place. I'm also going to talk a little bit about wills and trusts, and then I'm going to talk about some asset protection type strategies that you might use when thinking about planning and paying for long-term care. And then I know Brian's going to cover a lot of great information in more depth. I'm just going to kind of give a big overview here as we go through the basics of what legal documents should you have in place. Now, first, a little bit more about the firm I work with. It's Gantner and Capriano, and I am Paul Gantner of that firm. You can see also Charlie Amon and Jackie Capriano. We focus only on estate planning and elder law issues. And we do belong to the National Academy of Elder Law Attorneys, the American Academy of Estate Planning Attorneys, and we work a lot with the VA to handle veterans claims as well. This is really one of my favorite things to do of my job, and that is educating the community. I do over 100 events per year, and I really appreciate every opportunity because if we can help just a couple people put themselves in a better position, that just is the reason we do this stuff. And I got my college education at St. Louis University, and then went to Mizzou, and I got an MBA in finance and my law degree. And when I was there, I taught finance to the undergrad at Mizzou. And so I've really enjoyed this opportunity to educate the community really for my entire career. For the Missouri chapter of the National Academy of Elder Law Attorneys, I will actually be I'm the president-elect. So starting in January, I'll be the president of the Missouri chapter of National Academy of Elder Law Attorneys, and there are about 150 attorneys that are in Missouri that focus on the stuff we're going to talk about today. And our other speaker, Brian Quinn, was a past president only a couple years ago for NALA, so I'm really glad to get to co-present with him today. With the American Academy of Estate Planning Attorneys, I actually serve on the Board of Governors for the national organization, and so it's a great opportunity to learn what people are doing in other areas of the United States and help us focus our practice as well. So let's talk about having legal documents in place and what your options are. Your first option is to do nothing at all. And More than half of adults in the United States are currently using this option, which I would argue is not the best option. To say, you know what, whatever the default is, we're going to have happen to us. I'm sure the states put the right laws in place to protect me, and I don't need to do any planning or get any paperwork in place. And I'd argue pretty strongly against that position. I really think you're going to be in a better position by at least taking the next step, which is that idea of traditional planning. A lot of us think about doing estate planning as I got to get this document signed before I die. I got to get this document signed before I become incapacitated. And then you have this document and you think, great, I'm done. Glad I did that when I was really thinking in my 30s and we had minor children. Or glad I did it the week before my spouse passed away. And again, there's great benefits to having at least the paperwork in place, but I think that even better would be to start thinking about this as legacy and wealth planning. And what I kind of describe that is how do you want to be remembered, and what stuff do you have that we need to deal with, and then put together a plan for that. And then the documents will kind of be a byproduct of that, but in many ways the documents really are the easy part. So like many things in life, timing is everything, and you are going to have vastly more options in place if you get this started before you need it than if you wait until you need it. And of course, in the area of estate planning, if you wait until you need it, it's too late. And so we want to talk about what can you do today before you need it that's going to put you in the best place to succeed when you find these difficult situations. Because unfortunately, all of us are going to die someday at this point, and every day in America in 2019, 7,452 people on average died. And actually in 2020, I've seen recent numbers that show that numbers crept over 9,000 Americans die every single day. And so this is not a probability or a possibility. It is a certainty that we need to have some plan in place if we didn't come home today. And unfortunately, it's become very, very easy for this to be done poorly because of the mindset that most of us have that all wills are the same, all trusts are the same, or a power of attorney is a power of attorney. And I just need to find out how to get it the cheapest way possible. And I know that's what a lot of people think, because our office will get calls all the time that say, how much is it for a will? Or how much is it for a trust? Well, if these things were commodities and they were all the same, then in 2021 we'd kind of be silly to do anything other than get online and Google cheapest will in St. Louis and print that out. And I know I've looked in the past, and there are Groupons available. I've at one point found it for $29.99. You could take care of all of your concerns and desires, right? And obviously that's not the case, and many times you're going to have hundreds if not thousands of dollars that you'll need to invest in doing a very specific, well thought out plan if you're trying to do a lot of advanced planning and tax planning. And again, we're going to talk a little bit about that stuff, but we're going to focus a lot more on what can you do at the very base level, no matter how much or how little money you have, no matter how old or how young you are. There are certain things that you're going to need to have in place. So what are those documents that that we want to have in place? It's the title of our talk today, so I definitely want to spend some time on that. I use 5 must-have documents that no matter what type of other planning you want to have, every plan should include these documents and an update to these documents if you've got an old version of it. So the first is your property power of attorney, and that's really where you would appoint a financial or legal representative that can act in your place if you can't make your own decisions. Now, I'd often make this document immediate upon execution, which means as soon as you sign it, the first person you list would be able to write checks for you, or hire an attorney, or file your taxes, or talk to the utility companies on your behalf. And it's really any financial or legal decision should be covered in your property power of attorney. Now, that is not to say that all powers of attorney are created equally, because they're not. Unfortunately, as a lawyer, I get calls that say, hey, I'm the agent under my mom's power of attorney, can I do X? And I get to give them the lawyer answer, which is, it depends. It depends what that document says. And every word in that document makes a difference. And even when people have what's called a general durable power of attorney and they say, this person can do anything and everything in the world that I can do by law, it doesn't allow you to do certain things unless it specifically says it. In Missouri, they list out more than 10 things that have to be specifically listed if you're going to allow them to happen. And there's some of the most important decisions that you would need, particularly if we're trying to do asset protection or paying for long-term care or estate planning, kind of at the end of life stages. And gifting provisions, changing beneficiary designations, amending trusts that you've created or creating trusts that weren't yet in place are all things that would need to specifically be allowed by your documents, and they oftentimes aren't. Also, a lot of times the powers of attorney were done and when you were in a different part of your life and concerned about different things. And of course the laws were different 15, 20 years ago. So I see powers of attorney all the time that come in that say this person can make gifts only up to the annual exclusion amount. Well, that's great if we're worried about estate taxes or gift taxes, but most people aren't worried about that stuff right now. The current estate tax exemption for 2021 is $11.7 million. Most people don't have anywhere near $11.7 million. So why are we worried about making gifts that would affect the eventual gift tax or an estate tax if you're never going to pay that? However, we'd be limiting our ability to protect your last $40,000 or your last $100,000 if we're limited in the power of attorney from making any gifts or the amount of gifts that we can make. And a lot of people, unfortunately, have no power of attorney in place at all. And it's not until they've been in a memory care facility for 3-4 years and they realize that mom and dad can't make any decisions for themselves anymore that they say, hey, we need to get a power of attorney. Well, by then it's too late. And I know Brian's going to spend a lot more time talking about the guardianship, but generally a guardianship and conservatorship is not going to be the best way to put somebody in charge of your decisions. For one thing, that means that you no longer get to make any of your own decisions because a guardianship and conservatorship actually strips those rights away from that person and grants them to someone else. Whereas if you appoint them as an agent under a power of attorney, you can still do anything and everything that you could do before. It just allows this person to help you. And it's actually kind of rare that somebody goes, I can do everything, I can do everything, I can do everything, I can do nothing. It's usually going to be much better if you can do a smooth handoff as those things come up. Now, the next document I think everybody should have is a healthcare power of attorney. That's the document where you can appoint somebody, an agent, who can act for your healthcare decisions. So this would be talking to nurses and doctors about whether you should take that pill or not, or should you have that surgery or try the pills, or is it time to take this person off the ventilator or off dialysis. Now, as long as you can make your own decisions, you are the only decision maker that matters. Unfortunately, in Missouri, there is no default healthcare surrogate, though. So if you can't make your own decisions and you don't have a healthcare power of attorney in place, there's no one that can make those decisions. And so you're in a really tough spot if the doctors and nurses can't talk to anybody about whether you should have that surgery or when the right time to come off the ventilator is. So just by being your spouse does not give that person the authority to make those decisions, or just by being an adult child doesn't give the authority to make those decisions. It's really important that every person 18 years or older, regardless of what money they have or don't have, has appointed somebody to act as their healthcare power of attorney. And so everybody should do that. If you're on this call and you have not done that yet, make that a priority, is get your healthcare documents in place. We've all seen in the last year and a half how this can happen to anyone out of nowhere. An otherwise healthy person might be in a position where they at least temporarily can no longer make or communicate their decisions, and somebody else has got to do it for them. Now, the next one that we want to talk about is a HIPAA authorization. So you really want to name one person at a time to serve as your decision maker. However, you might have a group of people that you want to be able to get your health records if something happens, because if you got a phone call that your mom or dad was brought to Mercy Hospital in an ambulance, and you called up to Mercy Hospital and said, oh my gosh, what's wrong? My mom or dad was just brought there and I want to figure out what's going on with them. they can't even confirm that they're at the hospital, much less what their situation is, because it would be a violation of the health privacy laws under HIPAA. So if mom or dad were able to sign a waiver on the way in, maybe they'd authorize them to talk to them. But a lot of times you're brought to a hospital without the ability to sign that. And we want the very base level of the decision makers and close family, whoever you're comfortable with, to get that information. I've been in a hospital room where a doctor or nurses walked in and said, "Are you family or are you next of kin?" Those words don't mean anything when it comes to HIPAA violation. Let's say I say yes. That does not mean that you can just start telling me what that person's health situation is if they haven't allowed you to tell me any of those things under a HIPAA authorization. So make sure that you've got a HIPAA authorization for your spouse, for your kids, for anybody that you'd want to be able to get that access. Now, you should also put some thought into your advance directive and living will. And those documents do have some purpose for your patient directions in end-of-life situations. When there's no hope of a significant recovery and you have a terminal condition or a condition, disease, or illness without a reasonable expectation that you'll regain an acceptable quality of life, then you're saying, if the doctors can do nothing more than death-prolonging procedures, then I would prefer that they just make me comfortable and let me go. That's kind of what the living will says. Now, your advance directive would go a little bit further and say, hey, I might be able to live a long time with this treatment, but it's not the quality of life. It's not an acceptable quality of life for me, and I would want these things to be withheld and withdrawn and to just make things comfortable. You also would address in your advance directives if you have any religious items that you'd want included. For instance, being Catholic, it was important to me that I have last rites if I'm in an end-of-life situation, and before they pull the plug, so to speak, I would like to be attended by a Catholic priest. Make sure you go through those steps. And hospitals do keep that stuff on record if you have that in your advance directive, and it's really important that you go through that and talk about those things with your family as well. Now, sometimes people say, oh, do I have a DNR? Or should I have a DNR, a do not resuscitate? And that's a different thing from an advance directive or a living will, and not everybody should have an out-of-hospital DNR. Most people want to be given a shot. If the paramedics come in and find you unresponsive, get me going, get me to the hospital, stabilize me, try to treat me, and if we get to the point that you can't, then the living will and advance directive might kick in. But some people, if they're very advanced in age or have a terminal condition, they might talk with their doctors and actually get a medical order that says, if you find me unconscious in my skilled nursing room or at my apartment, I don't want the paramedics to resuscitate me. Maybe I'm concerned that they're going to break a bunch of bones in my chest, and again, that my quality of life will not be good enough for that to be worth it, and I would rather be let go at that point. Now, in Missouri, there's a special form for that and a special statute, and that's why I called it the purple form. It's supposed to be on purple paper and available in somewhere that these people would know that this exists. Now, nationally, there are forms referred to as physician orders for life-sustaining treatment, or POLST forms, that over 40 states have adopted this law that allows you to kind of have the standardized form. Also has to be signed by your physician and you in both the purple form and this POLST form, because these are medical orders. They are not patient directions. They're saying, hey, we've talked over with my doctor. We both agree that if I'm unresponsive, I just want to be made comfortable and let go. So again, this isn't for everybody, but some people might want to consider whether that's something that they should have. So when we're talking about legal documents to have in place, everyone 18 years and older should have a power of attorney for financial and legal matters. Everyone over 18 years old should have a healthcare power of attorney that designates somebody who can make decisions when they can't make their own. Everyone should consider whether signing a living will saying if only death-prolonging procedures can be performed, then make me comfortable and let me go. Everyone should have some advance directives that say, how would you want end-of-life treatments? Do you have any religious items that you would want in place? Or what point would not be an acceptable quality of life for you? And then maybe an out-of-hospital DNR would make sense. And then absolutely everyone should have HIPAA authorizations on file in case you can't sign those things when you go into the hospital or doctor's office. Now, many people should also have a will or a trust or both, but a lot of people have questions about those. So let me address the difference between wills and trusts. First of all, a will does not avoid probate. And one of the first directions that people tell me is, I want to avoid probate. And they're not sure why they want to avoid probate, and I know Brian's going to talk about this. But generally it's expensive, it takes a lot of time, it's public. But your will's not going to avoid probate. In fact, a will directs probate, which means it means nothing anywhere in the world except probate court. So it's not like you can just go up to the bank with your dad's will that says you were the executor and you were the only beneficiary, and they'd say, oh great, here's the money. The bank would say, go get letters testamentary. And they'd tell you that like you're going to go pick up a dozen eggs at the grocery store, but what they're really telling you is go open a probate estate. And so again, when Brian talks to you more about that, you'll see why you probably don't want that to be your only option. Now, that's not to mean you shouldn't have a will. I have a will. I know Brian, I'm sure, has a will. When you have minor children, as we do, your will is where you would designate a legal guardian. And thankfully we can't privately deal our children, so the will is where you nominate your guardian, and the court will eventually appoint someone as a legal guardian if their parents have passed away and they're a minor or disabled. And that's a very important thing to have. A will is also a great backup plan. You'd certainly rather have a will than have nothing if you find yourself in probate. So that's basically the will. Now, a lot of people say I want to avoid probate, and a trust is probably the best way to avoid probate because you can put all sorts of directions in there. I think of a trust like a tube of toothpaste, where you can appoint a trustee who's kind of the hand on the tube of toothpaste that's squeezing the toothpaste out onto the toothbrush, which is your beneficiary, and they're squeezing it at the time limits or for the reasons that you've designated specifically in your trust document. And meanwhile, everything that stays in the tube of toothpaste is protected. Maybe you're worried about divorces, or you're worried about creditors, or you're worried about them spending it all. Certainly I don't want my 5, 6, and 3-year-old to receive lump sums of money. I'd rather it be held in trust with some adult caretaker taking care of them. So there are a lot of reasons why you would not want to do other non-probate transfers, like doing just beneficiary designations. If you have a minor child, or you have somebody on government benefits, or you just don't want the person spending it all, or you're concerned about their divorce, or lots of reasons that you would want to put a trust in place. Fees and taxes, asset protections, long-term care costs, but not all trusts are the same. So again, if you Googled how much is it for a trust, you shouldn't find an answer to that, because you should be able to tailor make your trust for your specific situation, and it depends on what you're trying to accomplish. So most people put in place what's called a revocable living trust, where they are the trustees and they are the beneficiaries, and they can use the money for anything they want, just like when they had it outside of a trust. And it does a lot of great things to avoid both living probate and death probate. You can do great tax planning and, like I said, great protection for your beneficiaries. You might want to protect the money in case you pass away and your surviving spouse lives for a while, that they don't, if they get remarried, you might be concerned that they leave all the money to the new family and not to your children. Or maybe you've got a lot of money in IRAs and retirement accounts that you want to spread out over time. There's great benefits to preventing family fights and problems there. And of course, it's a great way to pass on your family values and experiences. But what they do not do is offer any asset protection or protection from future long-term care expenses. Revocable living trusts are not meant for that. So sometimes people say, oh, my mom and dad have this trust. Is it protected from long-term care costs or from bankruptcy and whatever the case may be? And the answer is no. That doesn't mean there's nothing you can do. We certainly could build a better bucket. And again, if you work with an attorney and law firm that does this type of work, and that's the goal that's stated up front, then absolutely there's some great things you can do for asset protection. Now, unfortunately, you can't wait until you need it, and I know, again, Brian's going to talk a little more about emergency planning situations, but you are in a much better place if you have these documents in place long before you need it. Medicaid has a 5-year look back. Veterans benefits have a 3-year look back, which means you can't just wait until you need the benefits and give all your money away or create an irrevocable trust. They kind of thought about that. You need to do it long before you need the help. Now, obviously, working with Voice, we're focused on long-term care expenses, and another reason to focus on long-term care expenses is because it's not a possibility that you'll need long-term care. It's a probability as you're approaching retirement. Even if you're young, at 20 years old, you have a 1 in 4 chance of needing long-term care at some point. But if you reach 65, you've got a 70% chance of needing long-term care. Now, a lot of people talk about avoiding estate and death taxes. Well, with the current $11.7 million exemption per person, far less than 1% of people that die are going to have to worry at all about estate and death taxes. And again, Missouri doesn't have a separate estate tax. Some states have a little lower exemption, but still, the vast majority of us have no concerns about paying estate and death tax if you know what the rules are. But with a 70% chance, once you turn 65, of needing long-term care, you should have a plan. And 40% of the time, you're going to have some time in skilled nursing, and 20% will be there for at least 5 years. And I know most of my clients say, well, I don't want to go into a nursing home. You know, I want to grow up and go to a nursing home, said no one ever. But these are the statistics, and it's something certainly worth planning for. And there's really only 5 ways to pay. So you'll want to have a plan that you put together. You know, what money do I have? That certainly plays a role. If we're worried about estate taxes because you have $11 million or more, well, then you're probably going to be able to afford whatever long-term care you need, and that's great because everybody takes money. You can afford to pay for home care for a lot longer. You can do a lot of great planning strategies. Now, if you have less than that amount of money but enough that you can afford long-term care insurance, that's another thing you should look into. Now, on top of the costs, though, that we need to take into account, we have to take into account that you have to qualify. So if you wait until after you have the stroke or when you turned 85, insurance companies know that's not a good bet for you. Certainly a diagnosis of dementia or something like that is going to prevent you from being able to obtain any sort of insurance benefits at that point. But if you're in your 50s or so, you know, it's a good thing and still relatively healthy to look into whether that makes sense. And certainly if you have a policy in place, you'll want to see how that fits in. Now, long-term care insurance is not your health insurance. Medicare and health insurance supplements and Advantage plans, they will cover some hospital stuff, some doctor stuff. They'll cover some rehab. They'll cover some hospice benefits, but they will not cover custodial long-term care either in the house or assisted living or skilled nursing. That's going to have to be some sort of long-term care insurance benefit. And then, of course, Medicaid benefits are in place if you're essentially out of money. Now, it's not unusual. In fact, more than half of the residents in skilled nursing are on Medicaid. So that doesn't mean people that never had any money and always had less than $5,000. It's usually people that used to have money that spent it all and now it's gone because they had, you know, significant healthcare costs. Now, it doesn't have to be you. If you plan ahead, you can protect it so that you can maybe get some help from Medicaid or veterans benefits before you qualify by default by just running out of money. In veterans benefits, you know, aid and attendance is a big benefit that we work with. If you're a wartime veteran, spent at least 90 days of active duty and at least one day was during when Vietnam was going on or when Korea was going on, those things, you don't have to have been in country, you just have to have been active during that period of war. That might pay over $2,000 a month to help you pay for home care or assisted living or any kind of skilled nursing benefit. So don't risk destroying your estate. The best way to risk destroying your estate is to turn a blind eye to it and not do anything. You've got plenty of time, hopefully, if you're healthy right now, to put in a thoughtful place. It's not something that you can just do once and forget about. It's an ongoing process, and hopefully you keep that in mind because there's a lot you can do when you start planning way before you need the long-term care, or start planning way before you become incapacitated, or start planning way before you pass away. So start planning way before you need it, and your options are going to be much greater, and you're going to be able to have a lot more control. As the old saying goes, failing to plan is planning to fail. And so if you start planning early, you can choose how you're going to pay for the care. You can choose where you're going to receive your care. You can choose who's going to provide the care. You can choose when it needs to change. You can choose who's going to make your healthcare decisions. You can choose who's going to make your financial decisions. That's why you want to do this planning. And it's very important for everyone to do some sort of planning. And I'm just so thankful that we have this great event to talk about, again, those people that have been sitting on the sidelines saying, hey, I'll get to it one day, one day, one day. You know, the time for procrastination is over. It's really our mission, both through having this event as well as our mission as a firm, to help families secure their legacy. And that means, how are you going to be remembered? And I believe the only way to do that is to embrace every client that we work with through a long-term personal advisory relationship. You know, a lot of our clients that come to us from using other firms say, you know, I met that person one time 15 years ago and I never saw him again. We talked for a half an hour, we talked for an hour and a half, we put together a plan, and I came back in 2 weeks later, I signed it, and I never saw him again. I never wanted to call them because I was worried about what it was going to cost and how it was going to work, and that's not the way it should be. If you're in a position of approaching retirement, it's a great time to say, hey, I need a lawyer as part of my team, just like I have an accountant or a financial advisor, and it's time to put some real resources and time into this. Our elder law team includes 2 social workers, which is a huge benefit. You know, I know there are so many decisions as you approach retirement about, you know, what supplement should I choose, or what advantage plan, or when do I take Social Security, or where should I receive this treatment or placement, or how much does it cost if I go into memory care, and what facilities are good, and all of those types of things. We have geriatric care managers, licensed clinical social workers that can help make that decision, which I think is a huge benefit and something you should think about doing. So with that, this is my time. I want to thank The Voice again. I definitely want to thank Jamie for putting this together, and Brian for co-hosting with me, and taking on the questions that I'm sure you guys will have at the end of this. I appreciate all the healthcare workers and everything they've done, especially this last year and a half, taking care of all of our parents and grandparents and all of us that have been in the most vulnerable states during a pandemic and you know, at any time. So you know, some of these pictures are from, we have a little group called Elder Elves, a nonprofit we started back in 2014, where we just love to come visit. Say thank you to the healthcare workers, but also visit the residents that maybe don't get a lot of visitors. So if you are with a long-term care facility, or your parent or loved one is in a facility that you think that would be a good thing, I encourage you to reach out to us, and we'd love to put them on our list and visit some of the residents that maybe don't get some visitors during the holidays, whether it's Halloween or Easter or Christmas or any of those days. So again, thank you. And with that, I'm going to pass it back to Jamie and Brian, and I hope to see and hear from you all soon. Thank you very much.
We are very, very grateful to Paul Gantner from Gantner and Capriano for such a thought-provoking and informative presentation this afternoon. It really is so much to thank Paul Gantner for this afternoon. Thank you. Our next presenter who is with us this afternoon is Brian Quinn. Brian Quinn serves individual and business clients in a variety of legal matters, especially in the areas of estate planning, asset protection planning, Medicaid planning, veteran benefits, elder law, and special needs planning. Brian is a certified elder law attorney by the National Elder Law Foundation, who Brian has been named as Super Lawyer of the Year by Super Lawyers magazine every year since 2018. Brian has held multiple positions with the Missouri chapter of the National Academy of Elder Law Attorneys and the Bar Association of Metropolitan St. Louis Young Lawyers Division, and is active for experts and entrepreneurs St. Louis. Good afternoon, Brian. Quite the introduction. How are you doing?
Thank you, Jamie. I appreciate it. Couldn't have that introduction without you as well. So thank you.
Absolutely. So lovely to see you. Good afternoon and a warm welcome, and thank you for joining us.
I'm sorry to say that I'm not going to have as many, as you see my slideshow presentation here, I'm not going to have as many pictures of me in either an Easter Bunny hat or a Santa hat. But, you know, I'm maybe not as good with the pictures as far as my presentation goes, but hopefully some of the content here comes through pretty well. So thank you, everyone, for joining me here today for the legal documents to have in place. Paul did a great job of kind of going over some of those really important ones to have in place just from the outset. So I thought, in order to sort of piggyback on his presentation, and he and I have very similar practices and very similar offices as well. So I thought what I'd do is maybe piggyback off this and go into a little bit more of the why do we do what we're doing? Why are we trying to put these documents in place? What are some of the goals we're trying to accomplish in sort of the big picture standpoint? And then what happens if we don't have these in place? What kind of court actions can we take? Various other solutions are there out there? And I think what you're going to find is, just like Paul said, the earlier you can plan, the more you can plan ahead for some of these issues, the better off you're going to be. So I talk a lot throughout the day. I'm going to take occasionally a drink of water here. That's how we are as attorneys. We love hearing the sound of our own voice, right? So let me go ahead, and without further ado, this is the feather in the cap portion of the presentation here. So just like Jamie said, I am a certified elder law attorney, and I've been listed as a super lawyer with Super Lawyers Magazine in the field of elder law here for the last, I guess, 3 years. Before that, I was what they called a rising star. And a past president, as I think Paul even said, of the Missouri chapter of the National Academy of Elder Law Attorneys. I'm accredited with the VA. I'm licensed in both the states of Missouri and Illinois. But probably the thing that I am most proud of in my life is my 2 kids, my 2 dogs, and my beautiful wife. So I live out in the West County area, sort of the Wildwood, Ellisville area of West County here in St. Louis. I've lived here the majority of my life. My practice is actually in Manchester, Missouri, in that area of West County near 141 and Manchester Road. So Paul went through some of the estate planning documents that you would normally want to have here. And I thought, just kind of generally speaking, I throw in this slide here to just talk a little bit about what is estate planning. And it's really, as I say here at the top, the process of anticipating and arranging during a person's life for the disposal of their estate. It's sort of a roadmap. That's really what I tell people when they come into my office, is what sometimes I'll ask them, and it's a very, I have to be about as morbid a 40-year-old as you will ever find, but I'll ask them, if something happened to you today, or if something happened to you and your spouse today, or if something happened to you and your significant other, or you and your children, what would you want to have happen? And a lot of people will go into different goals of, and basically how they want to arrange things. Estate planning is really out there to try to get what you want, to who you want, when you want, how you want, and the most tax efficient manner, and avoiding the probate process or any other court intervention. It's also about setting up documents and plans in place in case something happens to you and you don't die. So it's how do you make sure that you have good documents in place to allow someone to make decisions for you if you can't do that for yourself? And how do you protect, preserve, and extend your estate so that you can receive, if you ever need long-term care? If you ever, how can you have something in place so that you can make sure that you can receive care in a place where you want to be? Or maybe if you don't want to be there, at least the best choice that there is out there for you. And so I think that that's really kind of the goal of estate planning. And you'll hear a lot of the differences between estate planning and elder law. And in some ways, they're very similar. They dovetail a lot, but in some ways, they're very significantly different. So what estate planning is like I said, creating that roadmap to get what you want, to who you want, when you want, how you want. Whereas that oftentimes, other than maybe putting in place powers of attorney and some of the medical documents that Paul talked about, a lot of people come in with more of a goal to deal with their end of life. What happens after I pass away. So in some ways, estate planning is really focused on that end of life component. Whereas with elder law, although you think about that end of life component, certainly, I think of it more as focused on the during of life portion. So especially the retirement years and when you start needing long-term care, that's really what elder law is focused on. And protecting, preserving, extending money, allowing people to use their money during their lifetime according to their wishes. That's kind of the difference as you start to think of estate planning versus elder law. That's the big difference in my mind there. Now, elder law touches on a lot of things beyond just estate planning. Government benefits is a big one. So I talk about here in this slide about how traditional estate planning documents, your revocable trust, some of your more simple powers of attorney that maybe people have done traditionally. And if you go to an estate planning specific attorney, you may get some of these more traditional documents. Whereas if you come to someone who's not only an estate planning, but also an elder law attorney, you might get more expansive documents. Like Paul talked about, powers of attorney that are geared towards protecting your assets and preserving them for government benefits needs, not limiting you on the types of gifts that you can make to family members or organizations. So I always say that traditional estate planning documents may not help you out with current goals. And elder law is big in a big subject area in that it not only touches on government benefits, but care needs and retirement issues. It touches on real estate and family type issues. It really pulls from a lot of different areas out there, and some which are maybe not even legal in nature. Like I said, finances or accounting or care needs, things like that. And so to me, it's this big kind of puzzle that you're trying to put together for a lot of people. But as an elder law attorney, really your goals are going to be that you want to make sure that you protect people's assets, like I say here, using specialized trusts. You want to avoid probate, so that's always a goal from any estate planning or elder law attorney. You also want to honor healthcare wishes, maintain quality of life and care, create a legacy for someone's family. But I like to stop on this last one, because this is probably the biggest thing that gets me out of bed in the morning and gets me to the office, is you want to give people peace of mind. I have so many people that come into my office that say, Mom or Dad just fell. I'm caring for my spouse and I can't deal with it anymore. Someone needs to go to a community. I don't like what's happening at the nursing home that they're at. I don't, all kinds of different issues. And really, a lot of times what happens is we need to just kind of slow down, take a breath, and do some education with these clients as they come in, so that we can build a plan and prepare for things and use the facts that we have before us to give us good peace of mind moving forward. And to me, that is the biggest thing that as an estate planning and elder law attorney, I'm able to do for people. I have so many people that as they leave my office, they go, you know what, I came in here so worried about this, and now I feel like we've got some control over it. I feel like we've got a plan. And to me, it's so hard to do this just by yourself. Like Paul said, he has a 6, a 5, and a 3-year-old. I have a 4 and a 5-year-old right now. And I know that it takes a village to raise a child. But I also know from practicing in this area that it really takes a village to help people when they come into some sort of care situation or crisis where they haven't planned with the right legal documents ahead of time. And like Paul said, that for attorneys in our area, the way that we approach problems is we have to bring in other people, other experts. So that could be the voice, that could be medical providers, family and friends. I have on here elder care advisors, which is sort of an offshoot of our firm that we've created to assist clients in times of crisis. It's run by one of our employees. Her name's Deirdre Chakeen. And Deirdre is very, very good at, I wouldn't say that she's a licensed social worker or anything like that, but she's someone that performs a lot of those roles at our firm where, this just happened, what can I do? Those kind of crisis calls that we get from a lot of our clients. And part of her job is to just be abreast of what the resources are that we have in the community. Certainly Quinn Estate and Elder Law or another good legal provider is important. And also the client is always at the center of anything that we do. So those are kind of the important spokes in the wheel here as you start looking at anything related to a client situation. Paul talked about trust. And so I don't want to spend lots and lots of time on trust necessarily, but I wanted to hit on them again really quickly because they do so much from not only a probate avoidance standpoint, but from an asset protection, from a putting a roadmap in place for beneficiary standpoint. And as attorneys that practice in estate planning, Paul and I'm sure both of us tend to be a bit biased towards trust. And a lot of times people will say, well, if I do this kind of planning, you make more money. And while that may in the short term be the case, I will tell you that we as attorneys make way more money on situations where people don't do good planning. So it's the unwinding of things really that make attorneys a fortune. It's not the planning for kind of the inevitable and doing smart planning ahead of time, although that is also how we survive from day to day as well. But trusts can be great tools. And when I start talking about trusts, I think of them almost like LLCs and corporations in that they're a separate legal entity that you can set up during your lifetime to kind of manage your assets, not only during your life, but also after you've passed away. Revocable trusts are by far your most common type of trust, and they're the ones that oftentimes people will set up earlier in life. Probably 90+% of all trusts are your kind of more standard revocable trusts. Irrevocable trusts can be a great tool, though, in that what they do is they can help protect assets against creditors. They can help out with estate tax and gift tax planning. They can also protect assets while allowing for qualification for government benefits like VA pension benefits, SSI, and also Medicaid benefits. Some of the common features is maybe not the person creating it being the trustee, but oftentimes a family member is trustee. Sometimes depending on the type of irrevocable trust, and there are many types of irrevocable trusts out there, either the person creating it or possibly family members or sometimes both are the beneficiaries. And usually the creator cannot directly amend or revoke the trust, although there's usually ways that you can amend trusts. And as crazy as this sounds, in Missouri, there's a statute that gives you a set of instructions on how you can revoke certain irrevocable trusts. So there is some flexibility you can build into these things, but they can be incredible tools, especially when it comes to government benefits planning. And like I said, divorce protection, creditor protection, bankruptcy protection, estate tax, gift tax protections, charitable inclinations can be great uses for irrevocable trusts. There's all kinds of stuff that you can use these things for, but government benefits is probably the biggest reason why a lot of my clients will set them up. So the reason that people set up trusts for government benefits is for long-term care. And I know Paul started talking about long-term care, but I thought I'd just go ahead and sort of define the term. And when I start thinking about what I do on a daily basis, I start thinking of it in terms of activities of daily living. So there's the big six right here, which most of us, many of us at least, will do within the first 15, 20 minutes of when we're awake. So this morning, what I did when I opened my eyes in my bed is I looked around to see where my puppy is. So I've got a puppy, and she is a real puppy from a standpoint of she chews on everything. She's not completely housebroken. So the first thing I do is I sit up in bed really quickly just to make sure that if she hasn't been out yet, we need to get her out immediately. So I sit up and I get out of bed. That's called transferring. So transferring is getting in and out of a bed or a chair or a car. I practice continence, which is making sure that I hold my functions, my urinary and bowel functions, so that I can get that puppy outside as soon as possible. So once I'm done with getting her taken care of, I toilet myself. That's my third activity of daily living there. After that, I will dress, I will eat, and I will take a shower. I'll probably take a shower before I get fully dressed for the day, but I'll do all of those other activities of daily living. So if I had a need where I needed help with 2 of those 6 activities of daily living, that's your clinical definition of needing long-term care. Or if I have some sort of cognitive impairment that, such as Alzheimer's or the various forms of dementia that are out there, then if you have a cognitive impairment and need some prompts for these things, then you also have a long-term care need. Government benefits, oftentimes this is sort of this is my government benefits 101 slide. It's just kind of how generally most government entities look at your estate. Because when you go to apply for many government benefits out there, there's some sort of net worth limitation. And that could be SSI, supplemental security incomes, around $2,000. Medicaid's a little over $5,000. And the VA is a little over $130,000 for different programs there. But your most common programs, Medicaid's vendor program, which is your nursing home payments program, and the VA's pension with aid and attendance program, which is your long-term care payments for helping veterans and spouses defray their costs of care. And when I say that you can only have this much money, I say you can only have so much in your countable assets column. And that's generally going to be checking, savings, CDs, money markets, stocks, bonds, mutual funds, IRAs, annuities, and the like. Now, there are going to be exempt assets, things that those government programs aren't going to look at. Most of them aren't going to look at a principal residence subject to equity and or lot size limitations. You can have a car, you can have personal contents that you're using, term life insurance since there's no cash value, and irrevocable prepaid funeral policies as long as you can't get the money back. Those are going to be things the government doesn't look at. Unavailable assets, which are over in the right-hand column, are going to be certain types of Medicaid-compliant annuities and promissory notes, again, depending on the program that you're going for. Each program looks at those a little bit differently. Irrevocable trusts, gifts to family and friends, and gifts to charities. Those are things where you are divesting yourself of assets in some form or fashion. And usually each program will look backwards for a period of time. Usually it's either a 3-year period or a 5-year period, again, depending on the government program that you're looking at. And if you've done things that the government program doesn't like within those time periods, they can impose waiting periods on you before you can actually qualify for things. So when someone comes into my office with a government benefits issue, I'm trying to figure out what asset they have in what column. And if they have too much in that middle column, how we can sort of strategically position the assets into another column to expedite their eligibility there. Gifts are something that, although the IRS may allow a certain amount, $15,000 per person each year, that doesn't mean that Medicaid, VA, or even SSI allows those same types of gifts. So although the IRS may allow gifts without needing to report it or without taxes, other government entities that matters for. So if gifts are going to be a part of your plan, you need to do it with professional advice and with some sort of overall master plan there. The other thing that we want to make sure that we don't run afoul of is estate recovery. I'm going to go back 2 slides here really quickly. If you look at the top left-hand column under exempt assets, it says principal residence subject to equity and lot size limitations. Now let me go forward 2 slides. The Medicaid department's very famous for this one. So what they say is when you apply for their benefits, they say, we don't care that you have a house. Go ahead and keep it. No big deal. Because we can put a lien on that house up to the amount of benefits that we provide you during your lifetime. That's estate recovery. So not every program does this, but Medicaid is certainly one that does. So thinking ahead, again, planning ahead, like is a common theme throughout this entire presentation, whether it's mine or Paul's, is important because of the fact of estate recovery and other issues that might pop up there. Houses and estate recovery, like I said, are the biggest the biggest issue with estate recovery is houses, and there's just a whole lot of things that don't avoid estate recovery that most people might think, like a beneficiary deed or even some types of irrevocable trust don't protect against liens against the property from the state. So proper estate asset protection and long-term care planning, doing it through someone that knows these programs, a good estate planning and elder law attorney is always really important. I don't want to get away from one other thing. One other reason that we do this planning is, let's say that you have a family member or loved one that was born with a disability or acquired one later in life. That could be a brain injury. That could be a disability that comes from service in the military, or some sort of accident, or it could be Down syndrome, or it could be autism. There's a lot of different things that fall within the category of special needs planning. And so what special needs planning really is it's trying to figure out a way where you can ensure that your loved one has the government benefits that they need, that they have the legal documents in place that are allowed, and making sure that you don't have to necessarily disinherit somebody who's in that situation. You can actually set up a fund for them, again, usually through a trust, so that they can be taken care of for the remainder of their lifetime. And oftentimes the lives of someone with a disability may last beyond their parents' lifetimes, or maybe their spouse or siblings' lifetimes. And so we have to have some sort of plan in place where we can provide financial and medical support for them moving forward, even if their life may last much longer than those that initially cared for them and set those plans up. And some of the big programs you're going to see, supplemental security income or SSI and Medicaid, tend to be big ones for individuals that have those special needs considerations. Financial planning can be really important. Special needs trusts or supplemental needs trusts can be very important. And also guardianships in the situation where someone can't set up a power of attorney can be very important to appoint someone to take care of medical and legal financial decisions for someone. So we talked about what happens if, why we're doing the planning that we're doing, but what if we don't do any planning ahead of time? That's what you have the confused baby here for. So one of the big things that you see is you got to go to the legal system at that point. And so there are guardianships and conservatorships, which is an administration proceeding during your lifetime, where if you have someone who's under the age of 18 or the age of majority in your jurisdiction, which in Missouri is 18, then without a set of natural guardians, which would be their parents, the biological parents, either because they have lost the right to be your parents or maybe they've passed away, then at that point, you're going to be looking for someone to be appointed as a guardian of the person and a conservator of the estate. The other way that you see this, and maybe more commonly we see this, is disabled individuals that are over the age of 18 would also need a guardian of the person or a conservator of the estate. So I'm using two kind of interchangeable terms in a way. They're usually wrapped up in the exact same proceeding, but they're different in that the guardianship is really the person that's appointed for personal decisions such as medical, living, and education decisions. The conservator is the person that's appointed for financial decisions. Oftentimes that's the same person, but it doesn't have to be. Much in the same way that a financial power of attorney and a medical power of attorney can appoint different people for you. The court can appoint different people to take care of different things. So depending on who the applicant is, if it's a spouse or if it's a child or a sibling or a parent, you don't have to submit to background checks, but anyone else does when they're applying to be a guardian or conservator of someone else. You also may have to go through, you're probably likely to go through a credit check. So there is more vetting through the court process that you have to do. It is a court process, like I said. It's going to require a hearing before the court to determine whether the person is unable to care for their person or estate. And you're going to have a legal representative appointed for that person called a guardian ad litem or a GAL. The disabled individual can retain certain rights through the court process, maybe the right to drive or marry or participate in the voting process. The expenditures after the order of the conservatorship everything's basically monitored by the court moving forward. So you have to submit annual accountings if you're the conservator. You have to submit annual guardianship reports as well. So it's something that can be it's much more court hands-on than what most people want. And conservatorships also can sometimes limit the ability to do government benefits planning and asset protection planning and preservation of someone's estate. Usually the court looks at this as, we want you to take your money and we want you to spend it on yourself for the remainder of your lifetime. We don't want this being saved for other family members. Now, there are exceptions to that, but a lot of the times that's the way that the court looks at these proceedings here. So how do you avoid these things? You do the proper estate planning and get powers of attorney in place as soon as possible. So powers of attorney allow you to appoint someone to take care of your financial or medical decisions if you can't do that yourself. So do that ahead of time, ahead of any type of incapacity. And the hope is that you're going to avoid ever needing to go through this process, because you don't want the court deciding who's going to take care of your medical and your financial decisions for you moving forward. You want to be in charge of putting that in place ahead of time. Now, Paul also talked a little bit about probate, and I thought I'd follow up with that as well after a drink. What happens with probate is this is your post-death administration. So if you pass away with some asset that's just in your name individually when you pass away without a set of instructions on where it's supposed to go, then that asset's now in a state of limbo. Take your house, for example. This is a common one, or a car, which is another really common asset that people pass away with just in their name. So there's no set of instructions. We don't know who's supposed to receive that asset. We may have children that say, well, mom and dad told me that I was supposed to get that. And I even have a last will and testament that says that I'm supposed to get that. But you still need a court order through the probate process to actually have title transferred to you. So like Paul said, a last will and testament does not avoid probate. It helps in the probate process. It does make things easier, but it does not avoid it. It's just a letter that someone leaves to the probate court to tell them how to administer their estate. There's two different types of probate. One is more streamlined. It's called the small estate affidavit process. That's for any estates that are under $40,000 in total value. Everything else falls into what I call the regular probate category. And it takes a long time. Again, the last will and testament can help out quite a bit. It can tell the court who's supposed to be appointed to take care of things. It elects for what's called independent as opposed to court supervised administration, waives bonding requirements. It dictates who your beneficiaries are, which, by the way, if you don't have a last will and testament, the state does have a series of statutes that say who's supposed to receive your estate in the event that, again, you don't have any decisions made about that before you pass away. So one great thing about the will is it augments those statutes so that assets actually go to the right people after you pass away. but it can take 8 to 12 months. And a big chunk of that is the 6-month period of time that creditors are allowed to make claims against your estate. And another big chunk taken out of the estate, frankly, is the person that's talking to you. Attorneys take upwards of 3 to 5% of your estate, and that's a statutory base level that we're allowed to receive. You can even petition the court for more than that if there's a lot of time and effort and weird things that happen with the estate throughout the administration process. So a couple different ways you can use to avoid probate: joint titling. Problem with that is everybody passes away at some point. So even if you have multiple people on an asset, eventually everyone's going to die. So that's not the best way to do it. Transfer on death and payable on death designations can be really great tools as well, but they also carry with them some issues from a standpoint of, what if the person that's supposed to receive my estate is a minor or disabled, or they predecease me, or they have divorce issues, or bankruptcy issues, or creditor issues, or generally speaking, maybe they're dishonest and they're not going to divide this asset with the other people I think should be beneficiaries. So beneficiary designations have some drawbacks, which is why trusts tend to be the way that most estate planning and elder law attorneys lean towards when it comes to planning your estate. They're kind of your smartphone of estate planning. They do all kinds of things and anticipate things in the future that we can't see as issues right now. And I put in here, I just talked over this board, just some things as to why trusts have some advantages over joint titling and beneficiary designations. But you can and you should use a combination of these things to avoid the probate process. Sometimes that's listing your life insurance policy as payable on death to your trust, or your IRA as payable on death to your trust. So there are combinations of things that you can use. So I am also recycling one of Paul's quotes here. Failing to plan is planning to fail, and that's a Benjamin Franklin quote here. So the crossroads of success of your estate plan and failure is really how early in the process you decide to plan. And depending on what your goals are, it may be that you need something more than just your traditional documents, because again, traditional estate planning documents don't always help out, especially when it comes to elder law issues and government benefits planning. So with that, I would like to thank you guys, for everyone here for attending, and I would like to thank Voice and Jamie for allowing me the opportunity to talk to you a little bit today. This is a list of some of the key people that are first contacts at our office. Here's a great picture of all of our attorneys there. As I always tell people, we do offer a free consultation for anyone that attends this seminar. So if you'd like to take advantage of that, feel free to go ahead and call our office and set that up. So with that said, Jamie, maybe I can go ahead and I'll stop my screen sharing and turn everything back over to you, my friend.
Yes, indeed. Thank you so very much, Brian, for an excellent presentation. We are absolutely honoured to have you this afternoon. I was wondering if anyone has any questions that they would like Brian to answer. Please do share them in the chat window, the chat function on Zoom, and we'll do our best to help you. If you've got any questions at all, please do share them. We did have a couple in advance online. The very first one, I'll let you have a look, please, Brian, in the chat window, if any of them look.
Yeah, so a couple things that I see in here. Do you inherit your parents' debts? And the answer there is no. You cannot actually, you can transfer assets on to the next generation or beneficiaries, but you cannot transfer individual debts onto them. That is, unless they co-sign on those debts. So debts are something where you have to actually voluntarily agree to be bound by them. Or the other way that sometimes you'll see debts of someone's parents coming into play is, let's say that someone receives the family home, and that home has a mortgage on it, or a car that has a loan against it. Then you're still going to inherit those assets subject to that debt. So I believe that's the only way that you're ever going to see that you might, in a back doorway, sort of inherit someone's debt. But in reality, you can't pass that on to somebody else. So, a next question, it looked like, was, can a convicted felon be a guardian for the elderly? I believe the answer is no. I know that anytime that someone petitions the court, that especially if they're not a close family member there's going to be a background check that's run. And usually the court will, depending on the felony conviction and when it was, I believe that they would kick those people out. Although off the top of my head, I've never actually had that case come up before me. So off the top of my head, I don't know the exact answer, but I believe the answer is it depends on the type of felony and the time period. But I think I would lean towards probably not. But again, I don't have any experience with that exact case. The next question was, I understand that an executor can take a commission on income made on any asset from the date of death to its sale. Is that true? So an executor, and I'm going to answer this question in two different ways. So one is you can be the executor of someone's probate estate, and sometimes people will refer to the executor of their trust. The executor of the probate estate is called the personal representative, and there is a statutory fee schedule, the exact same fee schedule as attorneys have, that 3 to 5%, essentially sort of commission schedule that we are allowed to take. And a personal representative is allowed by statute the exact same fee as what the attorney gets. So the answer there is yes. With trusts, it's a little bit different in that you actually need to have the authority inside of the trust document given to you to take some form of compensation. And oftentimes you'll see trust documents that say, I allow this person reasonable compensation without any sort of explanation as to what reasonable compensation is. Usually that's going to be some sort of percentage of the value of the trust. And it's probably not going to be as high as what the probate statutes allow. Usually you're going to be looking at trust companies and things like that to determine whether or not a fee is reasonable, what a trust company would charge. So maybe it'll be a percentage or 1.5% or 2% of the trust estate, but usually not as high as the 3 to 5% amount. Am I responsible for payment of an exorbitant fee to assisted living facility that was a result of the facility error? That is probably a very fact-specific and contract-specific question. So the answer is we need to sit down and talk about that in a little bit more depth before I can really answer that. Exorbitant fee sounds really large and out of the realm of reasonable. But you wonder if it was maybe allowed by contract. So it might be something that contractually speaking you're bound to. It might be something that is especially if it's a result of facility error, it's outside the bounds of reasonable. But without knowing more, I don't know the answer to that question. Hopefully I'm not moving too quickly with all these answers. I'm just getting rapid fire questions, so I figured I'd give rapid fire responses here. That may be, Jamie, let me see if I have any other questions. Here, hold on, I'm getting a couple more here. How do you find a trust executor if you don't have a friend or relative to take on the responsibility? Man, that's a common question. And it's one where there are pay services out there. So I know that although I don't do this very often, once in a blue moon, I'll have a good client that will ask me to do this for them because they just have nobody else to do it for them. Usually it's a situation where it's a very charitably inclined person that literally just wants me to take care of everything after they pass away and transfer their estate on to charities. So I have done that in the past, but more often than not, I will refer someone to a trust company. And there's a lot of, most financial institutions have trust companies at this point. Most of your banks, Bank of America, U.S. Bank, Commerce Bank, Central Bank, First Bank. There's some standalone trust company, Assured Trust Company out of Kansas City, Midwest Trust Company has offices here in Clayton. TI Trust is another one. There's a whole lot of trust companies out there where you can pay a fee to them to administer your estate. And depending on what type of trust you're putting in place, it might be that you don't need them until you become disabled or pass away. Maybe you can be the trustee of your own trust until you get to a point where someone needs to take that over for you. So next question I had was, I'm having a difficult time finding a dual POA form. The insurance company requested a dual POA. I assume what you mean there is a power of attorney where two people are acting together, and meaning dual power of attorney form. And if I'm not understanding that question, if you wouldn't mind typing in the chat box and just clarifying that for me. Most of your standard forms are going to, if you look up one online, are going to ask for one person to be put into that place. I can customize documents for my clients in ways where a lot of just forms that you find online or maybe drafting software engines don't. And what you'll sometimes see with dual power of attorney forms is you'll see some where you have two people appointed, or maybe it's more than two people that are appointed to act together. So they have to act in concert. And then the question is, what if they don't get along? And you've got two people butting heads. How does anything get done? And then you also have powers of attorney forms where you've got two people, but they can act independently and apart from each other. And those can be really good from a standpoint of if you've got multiple, maybe it's family members or advisors that really do get along, they can kind of break things up and say, well, you do this and you do this. I see that on healthcare power of attorneys a lot, because maybe you'll have one person that's out of state, but might be visiting mom or dad whenever something happens. And then you've got one person that's kind of your day-to-day driver to the doctor or something like that. You have both people on that power of attorney. So it's just whoever gets to the hospital first can make those decisions. So that can be a really good use of those dually appointed powers of attorney. I think, Jamie, that's all the questions I'm seeing right now. Maybe give it another couple minutes here. If anybody else has any other questions, I still have voice and I have some water, so I can keep talking if we need to.
Please do. Don't be shy, folks. We have 10 minutes still, and I have input Brian's email address into the chat window just in case you would like to follow up. Here's another question from Beverly Man.
Yeah, so there was so another question came up and it says, when searching, I can only find the durable POA, was getting a bit confused. Durable is not specific to financial or healthcare. What durable power of attorney means is that it has some language inside of it and usually pulled almost directly from Missouri statutes that says, in the event that I become incapacitated, this it's durable in that it continues to be effective even after I become incapacitated. And that's really the only way that people think of powers of attorney. But there are some powers of attorney out there that are not considered durable. And as soon as you become incapacitated, they immediately cease being effective. And take as an example, a real estate closing. So you might be out of town and you say, I'm going to give you power of attorney to go ahead and complete this real estate closing while I'm out of town. Well, in the meantime, while I'm out of town, I get into a car accident and suddenly closing on that rental property or that vacation home, that may not be the best thing for me. So your ability to do that ceases to be effective because this is not a durable power of attorney. With both financial and healthcare powers of attorney, either of them can be durable. So you can make them either non-durable or both durable. you're going to see, and I mean, by and large, probably 95, 99% of the powers of attorney you're going to see are going to fall under that category of durable. But they may be a financial power of attorney, financial property, general provision type power of attorney, or they may be a healthcare power of attorney. But either of those types can be a durable power of attorney, if that makes sense. So it is confusing, though.
I'm so glad that we have you here, Brian. I'm so glad that we have you here.
Well, thank you. I'm happy to be here as well.
Thank you. If there are any more questions, please don't be shy. Or please do get in touch with Brian following today's session. We will be sending a recording out to all the attendees of today's presentation with the PowerPoint slides as well. And please do get in contact with Brian Quinn and Paul Gantner with any questions you may have. No more questions? Well, thank you so very much for your time today, Brian. It's been an absolute pleasure, absolute privilege to learn from you as well. Thank you so very much.
Jamie, can I ask you one quick question?
Of course.
The introduction had had some music. And I noticed that there was someone with almost a Scottish accent that was singing there. Was that by any chance an original by you?
It was indeed a Scottish musician, a good friend of mine actually called Colin Hunter. Although I do sing and play guitar also, I thought it would be too egotistical playing my own jam.
Well, I liked it, and I just wanted to say that good music choice, if nothing else. There.
Thank you so much. Thank you. Something positive and lovely. Yeah, that's Colin Hunter from Scotland. He'll be very delighted. No, it's been an absolute privilege to learn from you this afternoon, Brian. We're always so grateful to you for these presentations and for your support of the education series at Voice. Of course, we do believe that it's so important to empower individuals with knowledge, with information, and we are very grateful that we have the opportunity to learn and for your time. Thank you so very much, Brian. Thank you.
Thank you. Thank you very much too, Jamie.
Thank you. All the best, everyone. There is a survey that we are asking attendees to complete with any feedback you may have for today's session. At the end of the Zoom, you'll see it pop up on screen. Please do share your feedback and we will be very grateful to you. And I hope you have a great rest of the afternoon. Once again, thank you to Paul Gantner and thank you to Brian Quinn. All the best, everybody. All the best.
Thank you, everyone. Have a good day.